So, hi everybody, both you who are here in this room and you who take part in the conference digitally. I will talk about the new consent law in practice in Sweden, and it's a review that I and my colleague Lars Levenhagen has done about the changes in the law that was introduced in 2018 in Sweden. And this law was both welcome and criticized when it was planned and introduced. The changes had long been requested by women's organizations as a very important societal message, and they were very happy when the law was introduced, that it would be clear that all kind of sexual interaction must be based on consent. That's a clear message. And also that it could lift the guilt and the shame that many victims feel and really put the blame where it should be. But however, the proposed law was criticized by several influential legal bodies, and especially many legal bodies, but the Council of Legislation, which is the most important remittal body, they said, and it consists of judges from the Supreme Court. They said that the problems with its applications can result in compromised legal certainty. And I heard yesterday that you have had this discussion recently here in Estonia also, so then you can relate that to the experiences from Sweden. And the basics of the new rules, it's that it's considered a rape to have sex with someone who does not take part voluntarily. So it's a clear message, so to say. If the perpetrator is aware of that fact, it's an intentional rape. But there is also a new rule saying that if he was, it's mostly a he in these cases, was not aware of that, but knew that there was a risk for it, it's considered negligent rape. And the new rules came into force in July 2018. And the central themes in our report is that we studied trends in rape reports. Have the reports increased? What has happened to the amount of prosecutions and convictions since the law was changed? And have the intentions of the legislator been realized? And are there problems with interpretation and with evidence? And that's one of the central questions. And also, what are the consequences as regards to the length of prison sentences? As if you widen the law and that has the same minimum sentence punishment, what will then be the consequences for those more severe cases with violence and so on? And the data collection, we gathered crime statistics on rape against adults, and we went through all court verdicts from 2019 concerning rape against women. And when we did that, we put those cases in a special, we put aside those cases where we had the concern that we don't think that this was illegal before the law changed. And in these cases, we contacted the prosecutor and asked what she and he thought about it. And if they said, well, I wouldn't have prosecuted that case before as a rape, we defined it a new case. And by that we could identify 76 new verdicts concerning rape that had gone to court as a consequence of the new law. And these cases we read especially thoroughly. And then we had surveys and interviews with police officers, prosecutors, judges, and defense lawyers, and interviews with 3 women's organizations. And if I start with the development of the reported rapes, you could see that there has been an increase since 2016, and that increase has continued. But you cannot see that there is a sharper increase since the law changed. It's a trend that continues. So we can't say if the continued increase is a result of Me Too and new attitudes among women, or whether it's also a consequence of the new law, as women say, okay, I think I can report this as the law doesn't require violence or abuse of a vulnerable situation. But we can see that the number of convictions has increased significantly, and in a way that it didn't increase before the law change. It increased by 75% in 2019 compared to 2017. We did an earlier study in 2017, so we had something to compare with. From 190 convictions to 333. And 26 of the convictions concerned new rape cases, and 12 concerned negligent rape, that is then a new crime. But, as you can see, 38 cases don't explain the whole increase from 119 to 333. So most of the increase concerned old types of cases, and that means that the law has had effect not only on these clear cases of just no violence and abuse of vulnerable situation, but also cases where the prosecutor has argued that there was violence and the complainant has said that there was violence, but the judge thinks that that part of the case can't be proven, but they can still prove and see that it was without consent. So it has changed the whole floor of the law, the new regulations. But we shall, even if I start with a positive picture, we shall still remember that even today, 90% of all rape reports still don't lead to a conviction. So there is still very many victims who don't see a conviction of the perpetrator. And you can see, as I said, that the number of rape convictions have increased a lot. The earlier trend was that it laid very stable, the amount of rape convictions. But then 2018, it was introduced in July, so 2018 is only half a year with the new law. And then 2019, it increases even more. What is then the nature of the new cases? Well, it's mostly young people who have partied and so-called ended up in a sexual situation that got out of hand. The parties are often sharing a bed when the incident occurs. They don't have to know each other very well, but they're on the same party. And it gets late, and they have drunk, and they sleep over, and often several people in the same bed, and then something happens. It's less common with couples in these new cases. Most often it's acquaintances that they are dating or are at the same party. What is interesting to see is that these new cases who have gone to court, a very high proportion of them have not led to a conviction. The lowest line, you see that 50% of those cases were acquitted. And that's a very high proportion when you compare to before and with other kinds of crimes. And that shows that the prosecutors tested the new law at the beginning to see where do the borders lie, what is actually considered rape and not. And one can only hope that this share will increase by time, because it's a traumatic thing to take part in a court proceeding for both the victim and the perpetrator, or the complainant and the perpetrator. So I think that percentage will be lower, and a higher percentage lead to a conviction. What is then our overall picture of the law's application? And the picture we got is that the new law has been applied without problems in most cases, resulting in a conviction for intentional rape. And that, I think, is the most important found in our study, and also something for Estonians to take with them, so to say. The verdicts concern, as we saw it, clearly punishable acts. And most often there is evidence in these cases that are stronger than just witness testimonies. It could be a confession, it could be a mobile recording of what was going on, or people noticing what was going on in a room, or who were in the room. And several cases involve situations that mirror those mentioned in the proposal for the new law, and that is that the victim was taken by surprise, so she or he couldn't react before it had happened. And it's often situations that they lie in that bed, and she notices that the man has put a finger in her vagina without her consent. And the other thing is so-called frozen fright or passivity that are often an ingredient in these new cases. So I would say that the problems interpreting the law arise primarily in verdicts on negligent rape. But we also have gone through the cases and analyzed what kind of problems arise in those cases, even if it's not shown in those cases where there was a conviction. And one is when is a yes from a complainant invalid, so-called persuasion sex, that the man asks over and over again. And it says in the proposal that persuasion sex is not illegal. But when could it all the same be defined as sexual coercion? When did the woman have the power and the possibilities to really say no? What kind of coercion could she feel that perhaps are not, that he would be angry or violent if she said no, or that he will leave her if she says no, and so on. When is passivity a sign of consent, and when is it not? And the question is then, when is passivity a sign of a silent expression of consent, and when is it a sign of, or an expression of refusal that she feels some kind of like some frozen fright that makes it impossible to say more clearly no. And what is the significance of an earlier no from the complainant in the assessment of the act? And that could be early in the evening, and then they start flirting and kissing, and what is then the suspect supposed to understand about her will? Because we can see very clearly that the common thing with these cases is a lack of verbal communication, that everything is interpreted, and neither the man or the woman or boy or girl really express verbally what they want or what they think. So that is something that we really see must change for the law to be less needed, so to say. And the most problematic part is the question about what is gross negligence, because it is a line that is difficult to draw between what is legal and illegal. Because the court has to find proof of whether the man had an insight about that there was a risk that the other part didn't want to take part, and what is to be considered evidence as to the accused's thoughts and insights at the time, and what behavior by the complainant are to be considered invitations that might be misunderstood. There are several cases where they have been in the same bed and her body has touched his, and he has interpreted it as, well, that was an invitation, and then he had started to have sex, and then said, how could you do that? I have never invited you to things like this. So, and you can also ask a question, is there any risk that the accused's verbal skills affect the assessment of what they are thinking at the time? We can see some cases where the men are very articulate about how they interpret this woman's acting and women overall, and others that are immigrants or not verbal, who can't defend themselves equally well. And then we also looked at the punishments for rape. Do you know what the minimum punishment for rape in Estonia is? Anyone who knows? No? In Sweden, the minimum penalty is 2 years, and that was the minimum penalty already before. And we now see that the new cases, they mostly result in the minimum penalty, and negligent rape results in an average prison sentence of 9.5 months. Already unlawful acts now result in prison sentences that is on the average 2 months longer, 28 months. And now there is a legal proposal that rape overall in Sweden should have a minimum punishment of 3 years. So we shall see what happens. And as I said, we also interviewed and sent out surveys to different parts of the legal system. And it was interesting to see that their opinions could differ quite a lot. Police officers have both positive and negative opinions, and they are the ones that come closest to, as they made in interrogations and so, to both the complainant and the suspect. And they feel that it's not easy for them, and the prosecutors don't tell them very clearly what kind of proof are they supposed to gather in these new cases, and what proof level is needed. And also that they could feel sympathetic to both the suspect and the complainant in these cases, that it was for them, they could see that the guilt question wasn't so 100% clear every time. Judges and the prosecutors, they were very positive. All the interviewed prosecutors and had just positive experiences, and they said also that it's a very important message to society that consent must be the base. defense judges had limited experiences, as most of them hadn't had so many cases, but they hadn't faced any problems, contrary to what the Supreme Court had thought would be the case. Defense lawyers, on the other hand, find the law too ambiguous, with legal certainty compromised. They were very united in that view. And many cite the line between intent and negligence being difficult to draw. And then we come to Brå's assessment, and we think that the intentions of the legislators have been realized in several respects. And we don't think that the fear that it wouldn't be possible to handle in a legal, secure way has been realized. But the law, however, results in problems drawing a line between legal and illegal acts in some cases. And despite this, the new convictions for intentional rape have most often not been close to such lines. And we also assess that the problems lie with the new rules about negligent rape. Quite often we consider that a verdict of rape either would have been a better solution, so to say, or that an acquittal would have been the natural thing, rather than the conviction of negligent rape. And as has been, I suppose, discussed here in Estonia, one must also ask the question, is the legal protection for those who are reported but acquitted sufficiently strong? Because when it comes to the victim or the complainant, that is anonymized in the verdicts. We can gather verdicts, but then you can't see the name of the verdict. But you see the name of the suspect. And I've been called up by several mothers to young men who are acquitted in court and say that their future has been very affected by this. That they have not been able to take the job that they had planned, and they are, well, so one could think perhaps that if there is an acquittal, both parts should be anonymous for the party. And we absolutely need more precedents. That's the opinion of both prosecutors and judges and lawyers. And, of course, it's important to continue monitoring how the law is applied. But I would say the main result is that this has had a good effect, and the important thing now is that the message from the law is really spread in society, what the law says and what it means. And perhaps especially in schools, that this is taken up and clarified to the young people. And I hope also that the school will try to make the girls speak up more clearly also for their will. So we hope that will prevent the need for the legal system to react to rape. Thank you.
Thank you very much, Stina. This is for you.
Thank you.
Thank you. And we have questions. What is your response to the critics of the new law who argue that it might be in contradiction with the principle of presumption of innocence? It's the opponent's main counter-argument in Estonia.
Yes, I hope that I it has worked, I think, well, but it needs courts that are aware of the borders of the law, and there must come more precedents. And I wouldn't recommend Estonia to introduce a rule of negligent rape, but the consent law, when it comes to so say ordinary rape, that has, I think, worked well in Sweden. And it has really, I would say that the strong critics among the judges, we didn't find that when we interviewed judges, when they had worked with it for 1.5 years. So.
All right. Do you also have research on why 90% of rape reports still don't lead to conviction?
Yes, we have. I myself and my colleague made a study 3 years ago or 2 years, that was called Rape from Report to Conviction. And then we went through 800 reports and went through all the material. What happened? When was it acquitted? Yes, taken away from the process, and what did that was the reason for that? So we analyzed all. Was it a proof? Mostly it was lack of proof, but there were also other that it wasn't illegal at the time, and it was that the girl didn't want to take part anymore in the process. But we also evaluated a new specialized unit for rape half a year ago outside Stockholm, Sollentuna, and we could see that everyone was very content with their work because they had much more resources and all were specialized, and they didn't have to compete with cases of murder and so on. They could really focus on these cases. But we couldn't see that their number of convictions, the conviction rate, was higher than in other parts of Sweden. So it is, I think there is a limit to how high proportion of cases can be prosecuted and convicted, and perhaps one also must think in a wider perspective. How can we meet the victims in other ways than just the legal system, and what can the legal system do to make it the result as good as possible for the woman, even if there isn't a conviction.
All right, and the last one from here, actually there's more questions on the web, but that if you find time, it would be nice if you answered them. How is the law affecting rape reports that are set in the intimate partner relationships?
Well, if there are cases like that, they are interpreted in the same way. But these cases are not so common. It's more common with these new cases that the parties are acquainted.
Mm-hmm. Thank you very much.
Okay. Thank you.